Welcome to the Workology podcast, where we discuss the science and art of the workplace, gain powerful insights, resources, and perspectives on the industries of human resources and recruiting. Join your host, Jessica Miller-Merrill, chief blogger of bloggingforjobs.com, for an in-depth and no-holds-barred look into the future of our most powerful business asset, the employee. And now, welcome your host, Jessica, with this podcast episode of Workology.
Welcome to the Workology podcast. Thank you for making us a part of your week. June 2015 was a busy week in the human resources and employment law space, first with the Supreme Court decision regarding the Affordable Care Act and also their same-sex marriage decision, which we are talking about today. The Supreme Court ruled by a 5-4 vote that the Constitution guarantees a right to same-sex marriage. And that's what we're going to be talking about today. Our guest is Jonathan Siegel, an employment lawyer with many years of experience on human resources and employment law issues. He serves as the partner and managing principal for Duane Morris Institute. Jonathan, welcome to the podcast, and tell us a little bit about yourself.
I am an employment HR lawyer. I'm a recovering litigator. Did it for 10 years. Glad I did it. Equally glad I don't. And now I work with companies to maximize compliance, not only from a legal perspective, but also looking at what makes the best community, the best culture, and therefore the most productivity.
We are today going to be talking about the recent Supreme Court ruling regarding the same-sex marriage decision. It is something that has filled my Facebook wall with rainbows and just lots of conversation, media attention, but I'm really interested in how this decision is going to impact human resources, particularly benefits and maybe the workplace.
It's a great question because there's an emotional reaction, and while I've seen many rainbows on Facebook walls, I've also seen many tweets that go the other way. And I think it's important for us to remember that not everyone agrees. It was a 5-4 decision. The decision clearly is consistent with the increasing support of same-sex marriage. So it's not like it's athwart where the dominant culture is, but it was still a 5-4 decision. I think that if you look at the case, and I know everyone has so much free time, but if you read the last paragraph of Justice Kennedy's majority opinion, and you read the last paragraph of Chief Justice Roberts' dissent, in many ways those paragraphs summarize everything else. In short, and what I like about them is, although I like when people dissent in a respectful way. Dissent's a good thing, so long as it's respectful. And I think Robert's dissent was very respectful. What does the case mean? The history of the case, and I know everyone's just dying for a last lecture in legal history, but the courts have held that there is this right of privacy, a fundamental right of privacy, started with contraception, expanded to other intimate decisions, and then one of them was striking down a ban on interracial marriage. And in many ways, I think that ban, having been struck down, sort of was open the door to say, well, we need to ask the question whether certain historical restrictions on marriage are still applicable. And the Supreme Court dealt with a number of objections. The majority dismissed each of them. I'll just mention one. One objection was the purpose of marriage is procreation. And as the majority said, that would mean we wouldn't allow people over 50 or people that are infertile to marry. So the majority took the objections, rejected them, and said this is a fundamental right. Those who seek to marry are not trying to demean it. To the contrary, simply wish to be part of it. The dissent, and there were 4, sort of unusual. Each dissenting judge wrote a different opinion with varying degrees of vigor. But what Justice Roberts said was, in a gracious way, congratulations to those who have gained something from today, and effectively wishing people well, but said this is not from the Constitution. So his view was this isn't a constitutional issue. Not saying one way or other whether it's a public policy, right or wrong, saying it's not something that the court should be deciding. So it was a very, people are still reading the opinion. I'm surprised how many non-lawyers are reading the case. But in the workplace, there are a couple of ramifications. Number one is you have the FMLA. And we know that, among other things, people can have time off to care for a spouse. Now, the Department of Labor said it's based on if you're lawfully married, then you're lawfully married. The state of celebration. The Fifth Circuit said we disagree. Based on the Supreme Court decision, I don't think the Fifth Circuit's decision can hold. So I don't know how we're going to get there, but eventually the law will be clear that individuals will be eligible under the FMLA, time off to care for their spouse, whether it be same sex or opposite sex. You then have some state laws, and state laws granting additional time off. And some of them may define, or local laws, may define spouse as that is between a man and a woman. Those laws can't be inconsistent with the federal Constitution. So employers may need to interpret those laws in light of the Supreme Court case and say, okay, the state or local law says opposite sex marriage only, but we now know that's not constitutional, 5-4, so we have to interpret this law in light of the constitutional reasoning. So I think employers could say, no, I'll wait until I'm sued and lose, or they could say, I'll take that position. So I think for leave laws, we're going to see a clear implication. Another implication is going to be with health insurance. And many employers offer domestic partner. This decision doesn't say you have to, it doesn't say you don't have to. But if employers offer to same-sex couples and not to opposite-sex couples, that will be problematic, to say the least. So employers are going to need to define in their health plans, spouse means spouse. And I suspect over time, the word same-sex versus opposite-sex marriage will go away. We'll simply be talking about marriage. Marriage is that between two consenting adults. And if plans don't say that, then those plans are going to need to be changed. It's not just health insurance. It may be life insurance. It may be disability. It may be a variety. It may be bereavement leave. To the extent those plans or policies are predicated upon the assumption opposite sex spouse, then the assumption needs to go away and just needs to be spouse.
So we're really early in this decision. So at the time of recording here, it's just been a few days
since
the announcement. Do you think that HR professionals, business leaders should be going out right away and updating their policies, or should they be waiting and working with employment attorneys or reading the decision on their own and making interpretations? What's the best recommendation?
Yeah, it's a great question. I don't think people should wait forever. But I when there's a decision like this that is so monumental, I don't think you want to react immediately. I think you want to begin to plan immediately. You want to make a checklist. Where can marriage, the definition of it, intersect with things that we do? Policy benefits we offer, whether they be insured, retirement, paid time off. We're going to need, an employer can't make some of these changes on their own. They're going to, if they have indemnity insurance, they're going to have to talk to their third-party carrier. In some cases, there may not be a need. An employer may, for its policy, say, so there's no confusion. When we use the word spouse, we mean any lawfully recognized marriage. And you have to think a bit about the optics, I think the human resource part of how you say it. And that relates to another issue. The court talked a lot about different concepts and views of the Constitution. I don't think those happen too often in the workplace. But there are people that disagree with the decision along religious grounds. And just as I think it's important that individuals in same-sex marriages not be demonized, it's equally important that those who have religious disagreements not be demonized. The law is the law. There are many laws people don't agree with. But that doesn't mean that employers should ignore the fact that there may be some employees who don't agree. So I think employers need to be careful that if someone voices opposition, not to jump to the response, that's bigoted, that's prejudice. If they make homophobic comments, that's bigoted, that's prejudice. If the person says, but this is in my sincerely held religious belief, this is wrong, then to me you should say, I respect your belief, I disagree, but the law is the law. So I think it's important that not that we take the Supreme Court and we winnow down its ruling so everyone's happy with it, because that's not possible. But I think it's really important that the message be as inclusive as possible, that complying with the law, we're making these changes. I think it's okay to say consistent with the spirit of inclusion. But I also think it's important that employers not necessarily go as far as to say, this is a great day for everyone, because there are some who won't see it that way. For the record, I agree with the court. But at the same time, I recognize and have friends who don't. And the key is to be able to say, to embrace a decision without insulting someone who sees it differently.
So what recommendations do you have for HR professionals to communicate not necessarily the immediate change for like a policy or their benefits or the bereavement leave, but just in general to their employees?
Well, I think there are some changes that may be necessary. The most important thing I would be doing now is, I think it's a gift to know what you don't know. No one knows every issue. Every time I go I'm sending myself messages all day. What about this policy? What about that policy? And I keep thinking of issues. So to me, one of the things that an employer may want to do, and this could be right away, is, we're aware of the Supreme Court decision that held that same-sex couples have a constitutional right to marry. We are currently reviewing all policies and practice to make sure we comply with the law. In the interim, if you have any questions, please let us know. The message that goes out right away is, we see it, we hear it. One of the things is you want to seize control. You don't want every employee coming up to you and saying, well, what about this policy? What about that policy? And then you're thinking, and then people are going to say the wrong things. Mm-hmm. So I think the immediate thing you want to do is communicate. We recognize that this policy, that this decision may affect certain plans or policies. We're doing a careful review, and we're going to let you know what changes we'll be making, if any, and in most cases there will be some, as we make them. We'll keep you informed. I think that's something that every employer should consider doing now.
I would agree, because we can't communicate about change enough and remind them of policy, procedure, expectations.
That's right.
Over and over, just reinforce the company culture, the message, and just what's most important to that organization and its employee population.
Very well said. I agree with you. And and what you said about culture or community is very important. There's a wonderful book, I just forgot the name who wrote it. It's called The Dance of Anger. That I see that you're upset, so I get angry. I assume the anger, and then you become less upset. There's also the dance of anxiety. I don't know who wrote the book. I could probably write the second one. But the idea here is there are going to be employees that are anxious. Take the anxiety away from them. Go out in front and say, don't make people guess. What are we going to do? There are some government officials that are saying we're not going to honor this decision. I hope they understand what contempt of court means, and that eventually cooler heads will prevail. But there are still going to be individuals that are going to have questions. So I think a good employer says, the Supreme Court has ruled, we're a compliant organization. We're reviewing our policies and things carefully. And then employees aren't going to say, well, what are they going to do? And then they can sit back and relax a little bit. I think things like FMLA may be one of the most important ones to explain right away, because that one's easy. You just say spouse equals spouse. And then there are little things, and you use the word culture, I think, that I think becomes part of the training. You know, someone would say, I'm married, and they would see a woman, what's your married? What's your husband's name? You know, I've learned to say now, what's your spouse's name? So that there are sometimes assumptions that aren't born of malintent, they're born of historical reference. Changes occur. So even things like that, rather than saying to someone, you know, your husband or your wife, what's your spouse's name? As opposed to what's your husband's names or your wife's name. Those might be seen as, you know, micro issues, but they might also be seen as microaggressions over time if assumptions are made that are not necessarily true. So I see it as a non-discrimination issue. I think we're going to see, by the way, there's a reality that in 29 states, excluding local jurisdictions, people can still be fired because they are gay or lesbian. So someone could go into work and say, I'd like to add my spouse to my health insurance. Congratulations on your wedding, you're fired. And under federal and state law, in 29 states, absent cities or counties in those states, that would be lawful. Now, the EOC has taken the position that discrimination based on sexual orientation is a form of sex discrimination, and that's on the EOC website. So I think employers, even if they're in one of those states, and they engage in discrimination, run a legal risk under federal law, state law, in some cases local law. And then there's, of course, pretend there were no laws, pretend we're in Texas. You still have the issue of you don't want to exclude talent. But I think you're going to see from this a reactivation of the attempts to expand the civil rights laws to what some call the last frontier, sexual orientation and gender identity. The EOC has already done so in terms of its interpretation of Title VII. Many states and local jurisdictions have, but the majority have not.
You mentioned Texas, and I want to talk about them a minute because it's been interesting following the decision. Some of the counties in Texas immediately were allowing for marriage license to be granted, and others were saying technology does not support this. We don't have the means to be able to input this into the system properly. We need to update our system. Therefore, we're not accepting any same-sex marriage applications. I wonder if the same thing might also be happening in the HR technology space. So let's say that we have a piece of tech, maybe our HRIS system, that isn't in compliance with the federal law. Any recommendations there? Yeah,
I got to tell you, and I always like to tease that about the People's Republic of California with all their laws, and then Texas is sort of the other side of the coin, friends from both jurisdictions. I have to tell you, and I'm going to be naive because I'm not a technology whiz, but we split atoms, we open up hearts, we do lung transplants. I think we can probably figure out this technology problem.
I just wanted to mention it because
It's
I
a
think
great
it's something
point.
that's going to be very small that could cause a hiccup in something that could become very big for the organization.
But see, what you just raised is a critical issue, which is before you go out and say we're making all these changes, you have to figure out how you're going to do it. And there are ways having heard it's a systems issue. Well, someone's working on the system. So there have to be ways to do it. But your point is spot on, and I have to now, can I just stop and send myself an email? That's something you have to focus on now. How will our technology adapt to this? I believe it can be done. There's unbelievable things that can be done with technology, but you raise a great point. Before you go forward and start doing these things, make sure you have the infrastructure in place, and when someone says we can't, then you push back a bit and say, well, eventually everyone will. So if you're saying you can't, do you mean you can't today or you can't? Because if you're saying I can't comply with the law, then I can't continue to use you. So now let me try again. This is the law. By when will you be able to help me comply? And I think people will get there.
I like that. Well, Jonathan, I wanted to thank you for joining us today on the Workology podcast. Where can people go to learn more about you?
Are you sure they want to do that?
I would like to think this has been a great discussion.
Thank you. Well, first of all, I write blogs for SHRM. I love SHRM. If it weren't for SHRM, I would have left law years ago. I have a Twitter handle, Jonathan_HR_law, where I love to tweet, and I like to write a lot of blogs for SHRM blog, and just started a YouTube channel, and do a lot of writing of articles. So I saw Paul McCartney last Sunday. Oh, is that good? And it was called the Out There Tour. I'm out there.
You're out
People
there.
can find me.
Well, we'll link to all your social channels, your YouTube, your Twitter, and some SHRM blogs. I want to make sure that we include just the transcript of the last paragraph of the Roberts and Kennedy decision, so they can see that too.
I think it's good because I won't deny. I don't like to sugarcoat things. I like to be direct but respectful. One or two of the other dissents were a little more acerbic. And I get it. I've seen acerbic dissents on both sides of the court. But to me, the best way to increase tolerance for same-sex marriage is to understand, not necessarily agree with the arguments to the contrary. And the best way to increase respect for religious liberty is to show respect for those who've made a commitment, even if you don't agree. So, sounds kind of corny, but with some mutual respect, maybe it will never result in unanimity and agreement, but maybe there will be a more quiet acceptance.
Well, thank you, Jonathan.
Thank you
for taking the time, and thanks to you, everyone that is listening to the Workology podcast. We'll see you soon.
Production services for the Workology podcast with Jessica Miller Merrill, provided by Total Picture Media.